7 justices of the United States Supreme Court just blew a hole in the way this country has been governed for the last 3 decades, and you probably had no idea it happened. Not because you weren't paying attention, not because you don't care, because the institutions that were supposed to tell you about it decided quietly and deliberately to let it dissolve into the noise. The Supreme Court's 7-2 emergency ruling on nationwide injunctions is one of the most consequential legal decisions of our lifetime, and the people who benefit from the old system, the political class, the permanent federal bureaucracy, the media apparatus that feeds off their table scraps, collectively made a choice to muffle it before you could understand what it means. Well, it's not getting muffled here. This ruling didn't tweak a procedure. It didn't adjust a footnote. It ripped a weapon right out of the hands of the most powerful players in American politics and told them, with 7 of 9 justices in agreement, that the game they've been running for decades is finished. Every single American deserves to know what happened, why it happened, and what it means for their country going forward. So that's exactly what we're going to do. And if you're someone who is tired of watching the stories that actually reshape this country get buried under celebrity gossip and partisan theater, subscribe right now. Hit that button, because this is the kind of reporting that disappears fast from the places that are supposed to be doing it, and you need a place where it doesn't disappear. Here's something the political establishment, left and right, Republican and Democrat, think tank and lobbying firm, has never wanted ordinary Americans to fully understand. For decades, the single most powerful political tool in this country was not a bill passed through Congress. It was not a landmark election. It was not even a presidential executive order. It was a phone call. A phone call to the right lawyer who filed in the right courthouse and in front of the right judge and walked out with a piece of paper called a nationwide injunction. That's it. That was the cheat code. That was the shortcut that both parties quietly embedded into the machinery of American governance and exploited, without shame, without accountability, and without the slightest honest conversation about what it was doing. To the foundational structure of this democracy, to understand why this matters so deeply, you have to understand what a nationwide injunction actually is, and more importantly, what it was never supposed to be. When someone sues the federal government and wins, a court can issue an injunction, an order telling the government to stop doing whatever caused the harm. And that is what courts are for. That is legitimate judicial authority functioning exactly as the Constitution intended. The court sees an injury. The court orders a remedy. The remedy protects the people who were actually harmed. Proportional, just grounded in real legal principles that go back centuries. The problem, the catastrophic democracy corroding problem, is what federal judges started doing with that power somewhere along the way. Instead of limiting their orders to the specific plaintiffs standing in their courtroom, judges began issuing orders that froze entire federal laws, sweeping executive regulations and major national policies for every single American in the country. All 330 million of us, based on a lawsuit brought by a handful of plaintiffs in one city, before one judge, in one federal district that might cover a few counties in one corner of one state. Let that sit with you for a moment. One judge, one lawsuit. National policy frozen for an entire country. That is not a judicial check on power. That is a judge functioning as a one-person legislature, unelected, unaccountable, and completely insulated from the democratic process that every legitimate lawmaker in this country is supposed to answer to. And here is where it gets genuinely enraging, because this is not a story about one party abusing the system while the other played by the rules. Both parties did this enthusiastically, shamelessly, repeatedly. Every well-funded interest group, every ideological advocacy machine, every political faction with enough money to hire a creative legal team figured out the formula. Can't win in Congress because you don't have the votes. Find a friendly judge. Can't survive an honest democratic debate because your position doesn't command a majority. File your lawsuit in the district where you know the judge's politics align with yours. Get your nationwide injunction, and congratulations. You just made national policy without winning a single election, passing a single law, or convincing a single voter of anything. The Trump administration's policies were frozen this way. Biden's policies were frozen this way. State laws were frozen this way. Federal regulations were frozen this way. Immigration enforcement, environmental rules, healthcare mandates, executive directives, All of it was thrown into a legal deep freeze by single judges in strategically chosen courtrooms over and over again, under both parties. Across multiple administrations, the injunction became the great equalizer of American political warfare, not because it served justice, not because it protected ordinary people, but because it served whoever had better lawyers and a friendlier zip code. The Supreme Court of the United States just said that era is over. To understand why this ruling came down as an emergency order, why 7 justices felt compelled to act in the middle of the night without waiting for the full deliberative process that normally precedes a major constitutional opinion, you have to understand what was building in the months and years leading up to this moment. This was not a sudden reaction to a single overreach. This was a reckoning with a pattern. Multiple states, not one, not two, but a meaningful coalition of state governments, governors, attorneys general, and state legislators had gone to federal court with serious, well-documented, constitutionally grounded challenges to what they described as a systematic pattern of federal overreach. These were sovereign states with their own democratic processes and their own legislative authority. Looking at what federal agencies have been doing under the cover of emergency powers and executive directives and regulatory action, and saying clearly, you bypassed Congress, you bypassed our state legislatures, you rewrote our laws without a democratic mandate, and you do not have the constitutional authority to do that. Those are not frivolous claims. Those are the foundational claims of American federalism. And those are exactly the kinds of disputes the federal judiciary was created to referee fairly and impartially. And what did the lower federal courts do when those states came to them? They issued nationwide injunctions, blocking the state laws. Read that again. States challenged federal overreach. Federal courts blocked the states. The institution that is supposed to be the independent check on power acted as a shield for the federal executive, freezing state laws based on lawsuits that hadn't even been fully litigated, issuing sweeping national blocks before the actual constitutional merits of the underlying dispute had been heard. The Supreme Court had already sent warning signals. In Labrador v. Poe, the justices had placed similar limits on lower court power. Those warnings were noted, filed away, and ignored. The abuse continued without interruption, without accountability, without any genuine effort by the lower court system to rein itself in. The constitutional damage was accumulating in real time, and 7 justices recognized clearly, unanimously across ideological lines, that waiting months for a full merits decision was not an option. The emergency order came down in the middle of the night because what was happening required an immediate hard stop. An unmistakable message to every federal judge and every district in this country. The scope of your injunctive relief must match the scope of the actual injuries suffered by the actual people standing before you. One lawsuit does not give you the authority to govern a nation of 335 million people. That era is finished. Now, let's talk about what the justices actually wrote, because the language in this ruling deserves far more public attention than it has received. Justice Neil Gorsuch filed a concurring opinion, meaning he agreed with the majority ruling, but felt compelled to go further, to put something plainly on the record that he clearly believed needed to be stated without ambiguity. And what he wrote should be read by every American who cares about how their government actually functions. Gorsuch looked at what lower federal courts had been doing across this country and described it in terms that are extraordinary, coming from a sitting Supreme Court justice. These judges, he argued, had been functioning not as judges, but as mini legislators, unelected lawmakers, accountable to no one, imposing national policy on the basis of a single lawsuit from a handful of plaintiffs in one corner of a country that spans a continent. He argued with force and clarity that courts must return to what he called the traditional limits of equitable relief, the foundational legal principle that a judicial remedy must be proportional to the actual injury suffered by the court. Actual parties in the courtroom, you cannot harm one person and have a judge issue an edict covering 335 million people. That is not a judicial remedy. That is a legislative act, and legislative acts belong in legislatures. What struck me most about Gorsuch concurrence is that it doesn't read like a political manifesto. It reads like a justice who is genuinely, deeply troubled by what has happened to the separation of powers in this country. Someone who has watched the judiciary accumulate power it was never designed to hold. Power handed to it not through any formal grant of authority, but through the accumulated convenience of politicians on both sides who preferred winning through courts over doing the hard democratic work of winning through elections and persuasion. Now, honesty demands that we address Justice Sonia Sotomayor's dissent because she raised a concern that is legitimate and should not be dismissed. Sotomayor warned that restricting nationwide injunctions to only the specific plaintiffs who sued could produce a chaotic legal patchwork across the country, a situation where a law is blocked in some states but enforceable in others, where some Americans have court-ordered protection and others don't, entirely depending on whether they happen to be a named party to a specific lawsuit. That is a real problem. Inconsistent legal landscapes create genuine confusion, produce inequality, and in some cases can cause real hardship for people whose rights shouldn't depend on their geographic distance from a lawsuit they didn't know existed. Sotomayor is not wrong to flag those consequences. She was right to put them in the record, but here is why the majority reached the correct conclusion, even acknowledging the turbulence ahead. The alternative, a world where a single federal judge in a strategically chosen district can freeze national policy for every American, doesn't solve inequality. It creates a different kind of inequality, a more dangerous kind, one where the outcome of major national legal questions depends not on the merits of the argument, not on the will of democratically elected representatives, but on which courthouse you file in and which judge's name you draw. That is a lottery. And for decades, the most well-resourced political actors in this country have been gaming that lottery with precision and shamelessness. The Supreme Court just dismantled the machine. If you've been with me this far and you want to keep getting reporting that goes this deep on the stories that actually reshape your country, subscribe right now. Drop a comment telling me which of these policy areas hits you closest to home. And share this with someone who needs to understand what just changed, because what comes next is where this gets real. Let's get concrete about what this ruling means for your actual life in 2026, because this is not abstract constitutional philosophy. This lands in real policy, in real communities, affecting real Americans across every major issue defining this country right now. Start with immigration, because there's no policy arena that has been more thoroughly saturated with nationwide injunctions over the past decade. Immigration enforcement under multiple administrations has been fought almost entirely in federal courtrooms, with each incoming administration watching its enforcement priorities get frozen by injunctions issued by judges in jurisdictions that were deliberately chosen for their political alignment. Trump's travel bans were frozen by district court judges in Hawaii and Washington state. Biden's enforcement priorities were frozen by district court judges in Texas. The result was an immigration system that wasn't actually governed by Congress, wasn't shaped by democratic debate, wasn't administered through any legitimate policy process. It was controlled by whichever legal team filed first in the friendliest zip code. Under the framework the Supreme Court just established, that cycle becomes dramatically harder to sustain. A state can no longer watch its immigration enforcement apparatus get frozen by a court order triggered by plaintiffs in a completely different state with completely different circumstances. That is a fundamental change. Move to guns, because this has immediate consequences that every American needs to understand, regardless of where they stand on the Second Amendment. Multiple states have passed significant gun legislation in recent years, expanded background checks, assault weapons restrictions, red flag laws allowing courts to temporarily remove firearms from people deemed to be a danger. Multiple of those laws were challenged in federal court and frozen by nationwide injunctions before they could be enforced for a single day. Under the new Supreme Court framework, a state that passes gun legislation through its democratic process has significantly more runway to actually implement and enforce that legislation, while legal challenges work through the courts. The injunction is no longer an automatic kill switch that can be deployed the moment a law passes. Whether you support those gun laws or oppose them, you should understand what that means. The democratic process just got more weight. What voters and their representatives decide actually gets to play out before a single judge somewhere else can freeze it nationally. Then there is election law, which has been absolutely drenched in nationwide injunctions and is the most politically charged policy arena in America. Voting rights challenges, voter ID requirements, absentee ballot rules, redistricting fights. All of them have involved one side running to federal court and seeking a national block on the other side's policies. This ruling makes it dramatically harder to freeze election rules nationwide through a single lawsuit, which means that in 2026 and beyond, election policy will increasingly have to be decided where it was always supposed to be decided, in state legislatures and in Congress through actual democratic processes, rather than won or lost by which legal team filed first in the most accommodating jurisdiction. And then there is the environment. Clean power regulations, methane rules, water protections, endangered species enforcement. Federal environmental rules have repeatedly been frozen by nationwide injunctions issued by district court judges in states where the energy industry commands enormous political influence. That dynamic just changed. If you care about environmental protection, you need to understand clearly that the courtroom shortcut you may have been relying on just got significantly narrower. The fight moves to legislatures. That is harder, but it is more honest. Now, let's talk about where this goes from here, because what the Supreme Court did was seismic, but it was also the beginning of a long process, not the end of a fight. This was an emergency ruling, not a final comprehensive opinion. The underlying cases go back to the lower courts, which will now have to apply this narrower framework to the disputes at hand, and they will be doing so under intense, sustained scrutiny. So every federal judge in this country knows right now that the Supreme Court is watching that. Issuing a sweeping nationwide injunction without ironclad, case-specific justification is an invitation to be reversed fast and publicly. The federal government will push back. It will look for test cases where it can argue the national interest is compelling enough to justify broader judicial relief even within the new framework. There will be circuit splits, situations where different federal appellate courts interpret the new standard differently, and those splits will eventually force the Supreme Court back in with a full merits decision. This is the beginning of a legal recalibration that will unfold over years. It is not the end of anything. But here is what is not going back, what cannot be walked back, what the political class is quietly absorbing right now with something between shock and dread. The Supreme Court has formally, publicly, with a 7-justice supermajority that crossed every ideological line, declared that using nationwide injunctions as a political shortcut is constitutionally illegitimate. That declaration carries enormous institutional weight. It changes how lawyers advise clients on litigation strategy. It changes how advocacy organizations structure their legal campaigns. It changes how federal agencies calculate the risk of aggressive regulatory action when they know courts can no longer provide a nationwide shield on demand. It changes how state legislators think about their legal exposure. The entire strategic calculus of American law just shifted, and it is not shifting back. But there is a deeper truth embedded in this moment that needs to be said plainly, because it is what makes this ruling genuinely historic, rather than simply legally significant. For a generation, honestly, for decades, both political parties have been quietly, happily complicit in allowing the federal judiciary to accumulate power it was never supposed to hold. They allowed it because it was useful, because it meant you could win without actually governing. You could achieve national policy outcomes without winning Congress, without winning state legislatures, without doing the grinding. Unglamorous, genuinely democratic work of building coalitions and persuading your fellow citizens that your vision for the country is the right one. You could find the right judge and call it justice. You could substitute legal maneuvering for democratic legitimacy and sleep fine at night. The Supreme Court just slammed that door. It told the political class something it desperately does not want to hear. Democracy is supposed to be hard. Self-government is supposed to require actual governing. You do not get to win through shortcuts and pretend you've done the work of a free people. The question that will define the next chapter of American legal and political history is whether the people in power respond to this moment with the seriousness it demands. Will Congress step up and create clearer, more consistent legal frameworks so that the narrowing of injunctive relief doesn't produce the chaotic patchwork Justice Sotomayor warned about? Will state legislators engage more seriously with the constitutional limits of what they can? And cannot do and do more of the actual hard democratic work of governing, will federal agencies become more disciplined, more constitutionally grounded, and more restrained in how they issue rules and enforcement directives, knowing that the courtroom escape hatch is no longer available on demand? Or will everyone spend the next decade hunting for new workarounds, new loopholes, new creative legal theories to get back to the shortcut the Supreme Court just told them to abandon? Because that is a real possibility. Institutions do not reform themselves willingly. The people who built their power around the old system will look for every possible way to reconstruct it under different legal language and a different name. The court can draw a line. It cannot make anyone respect it. That part, the harder part, the part that actually determines whether this is a genuine constitutional correction or just a temporary detour before the next workaround, that part is up to the voters, the citizens, the ordinary Americans who elect the politicians, who confirm the judges, who pass the laws and fund the agencies, and ultimately determine whether the institutions of this country function with integrity or collapse into permanent cynicism. This 7-2 emergency ruling is a turning point, a real one. Not the manufactured kind that generates 3 days of outrage and then vanishes. The kind that gets taught in law schools and cited in courtrooms for the next 50 years. Whether it becomes a genuine restoration of constitutional order or just another chapter in the long American story of institutions that get reformed on paper and gamed in practice, that depends on what happens next. In legislatures, in elections, in whether the people who are supposed to govern this country finally accept that there are no shortcuts left, and in whether the citizens who are watching all of this decide to stay engaged, stay informed, stay present in the democratic process that this ruling is demanding they actually participate in. You stayed through the whole thing, and that matters. Because this is exactly the kind of story that gets buried under the noise, under the outrage cycle, under the partisan theater that passes for journalism in too many places. This story will not matter in one news cycle. It will matter in 5 years, in 10, in 20. So do something with it. Subscribe right now. Share this with someone who needs to understand what just changed. Drop a comment telling me which policy area you think this ruling hits hardest. Immigration, guns, elections, the environment, because that is the real conversation, the one that is actually worth having, the one that the people with power are hoping you never get around to.